Hi, my name is Jesse David Eisenberg with the JDE Law Firm. I'm a business litigation attorney, which means that my business is to protect your business. Today I want to talk about a frequently asked question that I often get, where people ask, what happens if the other side does not answer the complaint? But first, I just want to say that if you have any business litigation questions, you just want to chat about your business, or you have any questions about what you're going to watch today, you can go to jdelaw.nyc/consult. That's jdelaw.nyc/consult. And you can book a 10-minute phone or a 30-minute in-person consultation. Now, what happens if someone doesn't answer the complaint? Now, when you want to sue someone, you start with what's called a summons and complaint. Okay? The summons says, you are being sued, and you have to answer the complaint. The complaint is why you're suing someone. So, after they're served with the summons and complaint, the defendant has 20 to 30 days to answer the complaint. And then what happens if they don't answer it is very simple. What happens is you send a notice, by you I mean me as the attorney, I send a notice telling them that they are now in default and they have to answer the complaint. When they don't answer that, I have to file a motion for a default judgment. Okay, it's a standard motion practice. What you say is, I've sued them, they're not answering, I have a valid case, please give me a judgment. Now a lot of times, once the motion is filed, they wake up, they hire an attorney, and I can waste my time finishing the motion and going in front of a judge, but in general, and 99.9% of the time, a judge is going to let them file an answer late. Now, of course, the law says that they're in default, but again, the general rule that the courts abide by is that they want every case to be adjudicated and finished based on the merits of the case, not based on technicality of them not showing up. And even if you get that default judgment, if you make the motion, you show up, you go to court, they grant the motion for a default judgment, the other side can still open up the judgment. What they can do is file a motion to vacate. The motion to vacate always needs a reasonable excuse for why they're late, and it's usually something stupid, I'm going to be honest. My cat took the piece of paper, I didn't find it, something like that. And then there's got to be a meritorious defense to the action. They say, well, I don't deserve to lose the case because I have a good chance of winning based on X. Sometimes it wasn't me. They actually are at fault, not me. Something along those lines. And then the judge, again, within a year of getting that default judgment, the judge will open up just about every time. Okay, the reasonable excuse tends, it could be pretty stupid, but if the other side has a meritorious defense, the judge will stretch the reasonable excuse to make it work. Again, this is the majority of the time. It's not every time because it, again, is also based on the judge. But again, the court system wants cases to be won or lost on the merits of the case, not based on technicalities. Okay, so that's the long answer for what happens if they don't answer the complaint. Short answer is you can try and get a default judgment through a motion. So again, I'm Jesse David Eisenberg with the JDE Law Firm. I'm a business litigation attorney, which means that my business is to protect your business. And remember, if you have any questions about what you watched today, or you just want to talk about your business, or you have a possible case, all you have to do is go to jdelaw.nyc/consult. That's jdelaw.nyc/consult to book that 10-minute phone or 30-minute in-person consultation. All right. Thanks for taking your time to watch or listen to this. And until next time, take care.